Ladies and gentlemen, welcome to Murder Church. Get in here, ladies and gents. What are you doing? Sunday morning upon us here. Appreciate all the fine folks who are coming through here. Please give it a share, give it a like, all the good things. I'm coming through. Some more Aileen Wuornos. We haven't got much left here. A few more weeks, I would imagine. So yeah, let's go.
I get my hair out of my face while I'm doing this.
I know I was raped. You weren't nothing but a bunch of stuff.
Therefore, these proceedings are now...
Putting somebody who was raped.
Let's rock.
Hit the wrong button. Hit the wrong button. What's up, everybody? Welcome in here. Murder Church. Let me get some bells going out the gate before I forget about them. Hold on. Let's see if they're working. First of all, make sure I don't have to do anything special. Oh, yeah. We still got the bells in the house. That's what I'm talking about. The beautiful bells. We lost these things for close to a year, I feel like. It might not have been that long, but it was a minute. Glad everybody came through here. Hope everybody had a great weekend. Let me see who's in the chat right now. The beautiful people coming through. Right now. Boom. Semi Sharp coming through here. What's up, Semi? What are you doing? Mike Stevens in the house. What's up, Mike? Hope you're having a good weekend. Pokemon in the house. Sleuthy Sweetheart. Hope you're having a good weekend. Sharon, I got your email, Sharon. That was awesome merch that you made there. That looked professional as fuck is what it looked like. It looked cool. Also, I sent you an email back. Have you not received your package yet? It's really just like an envelope full of some goodies. But I did get that sent out, and I sent it to the address you sent to Mexico one, and I hope that it made it. That's the first thing I've ever sent to Mexico. And usually my international shipping can be hit or miss. I've had things come back from Canada. I've had really good luck with Ireland, actually. I've never had anything come back from Ireland. Had good luck with Australia, but yeah, Mexico, we'll see. Hopefully I get that, though. Am I missing anybody? Bassett Page in the house. Good. Pokemon, hope you're having a great weekend, everybody. Hope I'm not missing anybody. Carrie, there we go. Boom, all the beautiful emojis as well. Only way to use those Aileen Wuornos emojis, again, is to become a member here. A lot of folks in this chat, I know they're already membered up. One cool thing, if you do member up, you get something really, really cool. Boom, you become part of our Tuesday night book club. Tuesday nights, we usually watch body cam footage or something almost always police related. But immediately following that 8 Eastern show, usually about 9 to 9:15-ish, we go right into book club. We're reading the book, not the movie. If anyone's seen the television show from Netflix, Mindhunter, about John Douglas, and it's very good. It's super interesting. John Douglas is a little bit full of himself. I heard some people giving those reviews even before we started the book, when I started throwing it out there that we're going to be reading Mindhunter, but it is true. The man does not think that his shit stinks. Let's just say that. But it's very intriguing, and he's a very smart man. You can't take that away from him, and a lot of the things that he's done within crime is unbelievable. And he's a little creepy. He's a little scary, if I'm going to be quite frank, because, yeah, his accuracy with the way he can pinpoint a killer with bare minimum details is pretty freaking crazy. So yeah, please come through on some book club. I think we're going into chapter 11, 10 or 11. We're rocking and rolling that book. We listen to it all together via Audible in real time every Tuesday night. And if you become a member, you can hear all the past episodes as well. One thing that I got to get with her, and we make sure everything's still good, but this coming Saturday, we should be hanging out with Viv. We're going to have a very special Saturday live stream, and we're going to be having a puff and paint. And if anybody was familiar with that from when Jay, my boy Jay, the Shaming of Jay, did it with Viv a few years ago, I believe he made it a members-only type thing. This is going to be free to the public. This is going to be wide open. Anything in the future, who knows? We may do some special stuff. But this first one, I wanted to get everyone to get a chance to get in on and kind of have a good time, and hopefully come in and see Viv. Viv Who doesn't know Viv, she has a YouTube channel as well called Art with Viv, and she's amazing. She's an artist. She's great. She's super kind. She's super lovely, and we're going to have a good time. And I think she's wanting to do a Valentine's Day paint sesh. So, yeah, but she needs to get me exactly what we're painting because I want to get you guys the... turn the heat on. I'm already getting hot down here. I want to get you guys all the information. I want to get you what paint kit, paint supplies you need, anything that you may need that I can pass along. If you want to puff and paint with us, because I want to do it too. I want to see if I can make it happen. Who knows? We'll see. Not sure. Looking through the chat here real quick. Whew, not cooking this morning. I know Bassett's always cooking. I ain't got nothing to cook either. I got to go shopping today, which is my usual on Sunday. Sunday's my shopping day. 4 months right here, Sharon. That's right. Boom. Now I can actually hit you with one of these. I don't think I've ever hit you with one of these since you've been here. Hold on. Hold on.
Happy anniversary.
Happy anniversary.
Happy anniversary. Happy anniversary.
Happy anniversary. That's right. Sleuthie Book Club is the reason I joined, but I came in late, so I refused to show up. Well, you go back and watch all those other ones now. I don't know if we're calling them seasons or what, but there's a lot of content in there for people to check out. Got binging past chapters. Dude, they're super interesting. Even though those first chapters kind of lull just a little bit, once it gets into chapter 5 and 6, man, it really picks up, and he's going into some killers that, you know, I don't know every serial killer in, dude. He's blowing my mind with some of the information that we're doing. Yes, puff and paint is what we're going to be doing. The puff, I don't know. Hey, I don't know what. You can puff whatever you want to puff. I'm just saying. I'm just throwing that out there. Yesterday I was up to a channel that is called The Isolation Year. It's wild, live, and isolated for a year. Whoa, what is that? That sounds crazy. To a channel that is called The Isolation Year. I'm going to literally Google that over on the side. Hold on. I love weird shit like that. The Isolation Year YouTube. So what's this guy doing? Year 8. What the fuck? What does he do? 24/7 live stream. He doesn't ever talk to anybody? The fuck? That seems odd. I don't know what to think about this. I'm gonna have to look into that. I do love weird channels like that, though. At least just to check them out. I'm gonna put this over here so I don't forget about it. Boom. Dave, what's up? Sativa Steve. What's up, Dave? Hope you're doing good, man. Yeah, right there. Sleuthie showing off her 1-month membership. Uh-oh.
Happy anniversary. Son of a bitch!
Damn. That's awesome. Thanks for hanging out, Sleuthie. You're awesome. Everybody's so cool. Everybody's so kind. That's the bottom line. So yeah, I think I've gotten everything. I wanted to mention the Viv thing, book club, of course. And yeah, we're going to keep rocking and rolling here. We're starting out this morning with Richard Mallory's mother, Jacqueline Davis, takes the stand outside the presence of the jury. 42 minutes starting off here this morning with her. And yeah, let's get in here. Video tonight. One thing, there is a wheel currently rocking for any kind of donations that may come through. I may do the wrestling video wheel here today. Let me see. So yeah, a few fine, beautiful people came through and helped me out on the new wrestling video. And that will be a wheel for a free t-shirt. So I'll do that today. Let's see if we can get a second wheel on top of that. And let me see how far we are away from that. 7. So we need five more people to get a new, I don't know if that'll happen, but we could see. But either way, we'll give away a t-shirt and keep rocking and rolling. Let's go, Jacqueline Davis. Let's see what you got. I should have not cranked the heat up so high. I'm very hot now. My nose is freaking out. I gotta blow my nose.
We would at this time formally move for a mistrial, arising from the questions,
You don't say.
the manner of questioning, and the information elicited during cross-examination of Ms. Wuornos. As Your Honor heard, On a number of occasions, she was asked about matters that, and as Your Honor recalls, we tried to address this issue before she testified so that we wouldn't even get into this area. You heard persistent questions asked about other offenses, forcing the defense to instruct Ms. Wuornos not to answer those questions, forcing the court to sustain objections in that regard time and again. To make a long story short, Judge, we tried to take it up ahead of time, maybe once, maybe twice, maybe 5 times, but when you get into the extensive number heard in this case and the extensive manner and suggestion that was elicited during the cross-examination, we think that it would be incredibly difficult for a jury at this juncture to properly consider Ms. Wuornos' testimony and for properly assess the material issues in this case. I think the jury has been substantially tainted, and a fair trial as envisioned by both the Florida and federal constitutions cannot be had given that cross-examination and given the manner of it. As I said, you ask it once, twice, you ask it 5 times, but once it's clear what's happening, there comes a point where an attorney needs to stop. And throughout her cross-examination, that area was brought up and improper questions were brought up.
We were starting out hot. Yeah, you're damn right. Freaking mistrial out the gate. That's all they've really been asking for here. And of course, we can already know what Judge Turd Chet is going to say here. So, but real quick. Boom. Sleuthy Sweetheart helping us out, getting us down to 4 names to get us a will here for some goodies. Thank you so much. $2 starting off hot with a mistrial. Thank you, Sleuthy. I appreciate that. Had a few more beautiful people popping through too. Therapist coming in here. Just a crazy Jen coming through here. Saw real government name. What's up, guys? Morning.
Motion to record the jury.
Your Honor.
I'm sorry, I'm just trying to bring that back to Steve. Your Honor, there were, I don't want to offer legal argument on examining all the other homicides. I want to advise the court that my subsequent questions about other matters each time was provoked by an answer that the defendant gave.
I understand that happened too, but about what I said is good.
Yes,
before, and I'll say now for the record, is that as we're going on the tape, it's shown, remember,
yes, sir.
Our question was taken.
Yes, sir. The other matter, Your Honor, I wanted to bring it up before, outside the presence of the jury, didn't want to interrupt cross-examination. We're going to proffer to Ms. Wuornos her letter to Ty Moore, where she talks about the movie offers and the money. And that's a legal matter that I think you should consider outside the presence of the jury.
I haven't heard anything about it until right now. What is this letter?
Your Honor, for the record, we were going to announce we have no further questions of Ms. Wuornos at this juncture.
We had not concluded cross-examination. We had legal argument on several matters. This was one of them. So we reserve those.
John, I understood the record will speak for itself, but I understood cross-examination to be completed.
Subject to a request for a break, and I didn't.
Subject to our legal argument. I had finished cross-examination. Judge, we have several letters which she referred to them as we began to ask her. She has tried to say that Tyree Moore is now motivated by trying to make a lot of money out of her by the way she testifies. We have a letter from Ms. Wuornos to Tyree Moore telling Tyree that she wants Tyree to make money from movies and books from her life. And that she, in fact, suggested that to Tyree Moore.
Might be a good rebuttal some future time.
John, I'm sorry.
Well, like I said, I didn't want to do that in front of the jury. I said we had a legal argument, a couple things I wanted to present. I'd at least like to have her identify the letter and say, yes, that's my letter. 2
things, Judge. If we could have the record read back, my recollection is the state terminated its questioning, and that's what the 3 of us discussed over.
That would have called me. I don't know.
But I'm saying that's what I think the record will reflect, Your Honor. Secondly, and also importantly, is the fact that those letters are not material to any of the issues before the court. They don't relate to any material issues before the court. Ms. Jenkins asked about nothing that would touch on those types of things on direct examination. As Your Honor knows, we had a number of problems with the cross-examination, given the context of the questioning, and to then ask that the person accused be recalled to ask about something that is not a material issue as to the issues before the court in this case would be improper.
That is actually really interesting. Like, I don't remember, I probably wasn't paying that close of attention whenever the prosecutors did in their questioning on Aileen Wuornos last week. But yeah, they're saying they weren't done with Cross, and her team is saying, oh no, you were done, and you verbally said it, and the record will show that. Holy cow. Interesting. Therapist, coming through with a $2 holla. Missed y'all. Missed you. Thank you, Therapist, appreciate that. Hell yeah, getting us a little bit closer. We are actually really close to two wheels here today, quite frankly, because we're going to be doing one anyways. The one for a free t-shirt from the Secret Wheel that all the beautiful people came through for. That one's already happening. Can we get a second wheel? I think we're only 3 names away now. Thank you so much. Appreciate that. I'm going to give you a gun country for Aileen.
This is gun country.
This is gun country.
Give me the loot. Give me the loot.
Yeah.
They're not necessary.
We're not recalling, we hadn't finished.
My nose is killing me.
Your Honor, I would ask that the court reporter read back the
Read it.
exchange just before the break.
You know you're not going to get a knife in the heart.
I know how risky that is.
I know I'm muted. This judge fucking sucks, dude. Jesus Christ. Read it back. She wants to hear it too. We all want to hear it. Let's see exactly what happened. They're just like, well, you might not want to do that. It may end up looking bad on you. Fuck you, you turd-looking fat fuck.
Judge, Judge, momentarily, regardless of...
Let it.
Regardless of the word climate use, I made it very clear throughout, and they kept objecting that areas were blocked, that I would like to have some legal argument and a chance to address the court on those issues.
I said that was reserved for the legal argument. Now we'll see what happens. Everybody keep your mouth shut.
Come on.
No further questions, Your Honor. And then there was a request for a break.
But, Your Honor, that was not...
So fucking risky! Oh my God! How risky was that? How was that risky to begin with? Clearing up the fucking record so we know what's actually going on. So we don't have to hear old dipshit fucking argue about it for 5 more fucking minutes. So we can say, oh, I didn't actually get their ass got over after I said that. Apparently I went over here and I found a letter that I really would like her to admit to writing. Nah, dude, you done fucked up. Like, how ridiculous. No, they're dirty, dude. If she wouldn't have done that, they would have absolutely probably let him come on up, ask some more questions. This is a dirty ass
during cross-examination.
I can only interpret out what the question was. I have no further questions.
Well,
we can address that at some other time.
Yes, sir. May I respectfully advise, Your Honor, that I had believed I had very well preserved the right to
your argument is what I...
Yes, sir, which I had hoped would result in the court allowing us to reach these, I thought, were also sensitive areas. I didn't want to broach them outside the presence jury conference.
As I reversed myself many times through the course of the trial, I don't think I'll do it again. In light of argument.
Yes, sir.
This is actually...
Thank you, Judge.
Dirty.
I think I've been fair to both sides tonight.
That's true.
Judge, I have no question.
I have
never
seen, a prosecutor or either side say, I'm done, I'm done, I'm done, no further questions. And then, after the fact, try to say, well, actually, I thought the rules were that if I had something else, I could just at any time say, hey, come on back up.
And I have to admit, I don't always agree with you, but I know you're fair.
And I'm off in there, but they burned out.
Judge, whoa.
Mistrial denied.
Yes, Judge.
Of course, the mistrial is denied.
We will announce that we have no further questions when the jury comes in. Would Your Honor like to take up that other matter now, just through the jury part, then we'll do that again?
You need it now. Just a minute, bud.
3.5, wait a minute.
Oh, hold on. Do you want to bring this up now?
We could, whatever's
Well,
best. Do you want to do the jury
wherever you
stuff?
think it's the time. I put it up here so we don't forget it.
I think we need to end questioning first.
What is it?
It's the Jackie Davis issue, John.
That's all I have here. Lois needs to make a motion to raise Jackie Davis.
Why don't we do that, Your Honor? Let's just do it now. We had a bench conference with the court that was not recorded with regard to this issue, where the parties sort of gave the court an outline of their positions with regard to Ms. Davis. The defense would like to call Ms. Davis as a witness in the case. The subject matter of Ms. Davis's questioning, as we discussed at the bench earlier, will relate to, as Your Honor recalls, when I tried to ask questions of Detective Corzepa along those lines. Your Honor sustained the objections regarding Mr. Mallory's background and things along that nature. We discussed them at the bench, not to belabor the point, because Your Honor has suggested what the court's perception is. We would simply cite for the record State versus Smith, 573 Southern 2nd 306. Suggest to the court that that area of questioning is appropriate. And State versus Smith, 573 Southern 2nd 306. I'm sorry, Judge, I thought you said the site.
Keep arguing that. I'll be looking for that.
I was just going to give Your Honor a copy of the tape, then just ask that that be marked.
Copy of what tape now?
Ms. Davis's tape.
What you gonna say, counsel? Are you gonna make a copy, or is this just a? Is this what you intend? Is what you intend to be about?
You better show me which part you're referring to.
Doesn't take this name down for this lady cover.
Are we ready for the jury now?
Yes, Judge, I don't think we've ruled on the record, just if we can state our positions. As I understood it, the state objected to this line of inquiry, and Your Honor is ruling that it's, I mean...
That's a state objection.
Judge, that was cross-examination for Zephyr. Counsel hasn't made a proffer to the court. We object to the attempt to do so in some vague terms without any type of meaning for an appellate court to review.
Well, Judge, in that case, we would proffer the tape. I mean, I'd like to have it marked and ask that Your Honor listen to it.
Can I do that tonight?
You can do that tonight.
Your Honor, we're talking about an unsworn tape statement of a witness 2 years ago. We would object as that being the defense proffer. Counsel's got a proffer. Let's have one for the record where the court has something to rule on.
With the tape unsworn?
The tape is a statement made by Ms. Davis to Detective Corzepa.
Without counsel and unsworn?
Without counsel and unsworn.
I don't need to listen to it. I'll rule the way I earlier ruled.
Can we make it, can we just mark it and make part of the record?
Sure.
Thanks, Judge.
Go there, unsworn without counsel.
To Corzepa and Davis.
Judge, can we just, for the sake of making a record?
Hey, anybody coming through with shares right now? Appreciate that, guys. Hell yeah. Pokemon, Bassett Page. Thanks, guys. Sharing out the gate. I shared hers to start the morning, actually. Appreciate all those shares, guys. Those really help us out.
I'll be very brief.
Sure.
Yesterday, a statement was taken informally of Ms. Davis At that time, Ms. Davis indicated that any knowledge she had of Richard Mallory was primarily for a year and a half, that he was a sweet, decent, and caring man, and they had a relationship that led her to believe nothing other than that. There were questions asked about matters of his background, which she knew from no more than a hearsay, and she was very confused about the nature and circumstances of those, other than the fact that nothing that she knew was admissible as far as anything in his background. She had no personal knowledge of any criminal history, no personal knowledge of any propensity towards violence, no personal knowledge of his reputation for truth and veracity. The witness indicated that because of some difficulties she had because of an injury some 4 years ago, that she could not remember the statements that she made primarily in her statement to Detective Orzeppa. And in fact indicated that many of the statements made there were in error based upon her memory today. So we would submit to the court there was nothing that Jacqueline Davis could have offered that would have been allowed under the evidence code. There was nothing with regard to a reputation for violence. And I would submit to the court that alleged prior bad acts, which Ms. Davis indicated she did not have any personal knowledge of any such bad act or criminal history of Mr. Mallory, would have only served to confuse the jury and would have been inadmissible. They would have been in the form of pregnant questions with the court, I believe, sustaining the state's objection to those type of inquiries by defense counsel, as the court did when Detective Orzeppa was being asked of the third party answers by the witness.
Now, Judge, you, in terms of what Mr. DeMore said, you got an option.
Just for the record, both Ms. Jenkins and Mr. Miller were present during the course of the taking statement. Ms. Jenkins asked all the questions with the exception, I think, of one follow-up question by Mr. Miller, and it was left to the defense counsel to decide whether or not they wished to take a sworn deposition of Ms. Davis or not. They opted to take an unsworn informal statement of her. That lasted approximately an hour and 15 minutes in my presence.
A couple of things, Judge. As to the statement itself, that was by agreement of the parties at the request of Ms. Davis and Mr. Tanner, as I recall. I think we all talked, you and Tricia talked about it.
I can answer that if that was interesting to me. The statement by defense counsel, and I think it was Ms. Jenkins, was that she didn't care whether it was taken before a court reporter or taken informally, but she wanted to talk to Ms. Davis. She'd subpoenaed Ms. Davis. She could talk to him with or without my consent. And I said, I don't care which way you do it. And I conveyed to Ms. Davis it'd probably be simpler to just sit down and talk with the defense team and tell them what she knew. If they had anything they wanted, they'd probably call her as a witness. If she didn't have anything they wanted, that'd probably be the end of it. And with that, Mr. DeMore, Ms. Jenkins, and Mr. Miller, I remembered her to escort her to a private office she could use, went with Ms. Davis, and that was the last I've heard of it until now.
A couple of other things, Your Honor, as to the hearsay.
Not making any further profit.
Well, we don't want the record left as it is right now, because as to the hearsay that Mr. DeMore mentioned, the hearsay comes from Mr. Mallory. These are things that Mr. Mallory told Ms. Davis. As to the specific things Ms. Davis said, I'll turn it over to Mr. Jenkins and Ms. Miller, and Ms. Jenkins and Mr. Miller, because they were there.
Your Honor, my recollection of what Ms. Davis said is drastically different than what Mr. DeMore has represented to the court. What we found during this period of time we were discussing her relationship with Mr. Mallory, she informed me that 4 years ago she had a head injury and that she no longer could remember anything. The statement that she gave to law enforcement, I would advise the court, was in 1989, wherein she gave a detailed statement to Investigator Orzeppa. She also was able to remember dates. She could remember Memorial Day a few years back when she wasn't able to go on vacation with Mr. Mallory. So her memory was very selective. And she did not say that she had no knowledge of Mr. Mallory's criminal record or any criminal involvement.
Your Honor, you're going to subpoena the lady?
She's here, Judge. She's across the hall.
If you want to call her as a witness, bring her on. Let's get the camera rolling.
I thought we were debating, because Your Honor had ruled that she should not testify.
What I have said from the very beginning is I don't know what her testimony is, and I can't rule on it until here. I have said that.
Only dance.
And so I don't know what you want to do. If you want to take this now, I'll let that jury get out of there. If we're gonna call another witness, let's move on to the next witness.
Let's go.
And then we can come to her tonight.
What we would need, Your Honor, would be a hearing if, what we need to do is to call Ms. Davis and find out if under oath she will provide similar testimony to what she provided yesterday.
Get on your little phone there
And-
call her.
And then, Judge, sure, and then, but we should do that out of the presence of the jury, because the
I
question...
told you 2 weeks ago I would do that. I
Okay.
said, bring it on.
Okay, you want to
We
do that
keep
now?
talking about making the record right. Well, let's bring it on.
Let's do it.
Get here.
I think she's right outside.
Bring her in.
Your Honor, may we...
Bring her in. Let's get it.
Since this is
Here we go.
out of the series present, can we reserve objections to the proper?
We reserved everything for 2 weeks. We'll reserve it again.
Well, all I'm saying is, rather than interrupt and have objections that might be easier with that flow, I just want to hear we're waiting, Judge.
That's fair.
Thank you, Your Honor.
How are you, ma'am?
This is a proffer anyway.
Yes, sir.
Yes, Judge. As the judge just said, this is a proffer. It's testimony outside of the presence of the jury. Just, I guess the best way to phrase it for lay people is something for the court to consider. Could you state...
One thing now, Your Honor, also, since we're not going to be objecting, this lady's been subjected to a great deal in...
No, really, he really doesn't give a
She
shit.
has, no.
He's like, she ain't in jail yet? We ain't fucking put the chair on this bitch yet? Like, Jesus.
And one time have a
That's his
very
energy.
good relationship with the murder victim. And she has since been subjected to a great deal of the rigors of the legal system. And since we're not going to be objecting, I just ask the court to do what I know you do anyway.
All right.
Could you please state your full name for the record?
Jacqueline Davis.
Yeah, I agree with
Do
this.
you recall speaking to a detective in reference
Like, it's
to
a shit
Mr.
show, but I
Mallory's
also think that she deserved what probably happened.
appearance in October of 1988?
Yes. Well, not October.
Okay, when was it that you spoke to the detective?
It was in December.
December of 1988?
Well, I don't know the year, whatever the year was that he was.
Do you recall whether that conversation was after Mr. Mallory had disappeared?
Yes.
You just don't recall the exact date of it?
Well, it's in December of whatever the year was.
How many detectives were present during that conversation? Do you recall?
2.
And do you recall that they had a tape recording device that they'd been using?
Yes.
Do you recall the detectives asking you questions with regard to Mr. Mallory, his background, his history, things along that nature?
Yes.
At one point during the questioning, the detectives asked you questions, if you recall, regarding Mr. Mallory's history in the state of Maryland. Do you remember that?
We discussed Mr. Mallory in Maryland, yes.
Do you recall?
Could you speak a little louder? I can't hear you because of the wall between us.
Okay.
Do you remember what you told the detectives about Mr. Mallory, about what Mr. Mallory had told you about himself in the state of Maryland?
Yes.
Can you tell us what that is? What you remember telling them?
I told them that over a period of time, you know, odds and ends, that Mr. Mallory had said when he was a young man, he had been charged with burglary for entering somebody's house.
Do you
What kind of
recall
boy
telling
you
the
raise,
detectives that
man?
Mr. Mallory had been incarcerated for some time. That he had told you that. Obviously, you were not in Maryland, but that Mr. Mallory had told you that.
Objection, Judge. I know we indicated we wouldn't, but I withdraw.
Go ahead.
He told me he had been in a rehabilitative program.
Do you recall what Mr. Mallory told you, what you told the detectives about the circumstances of the burglary?
That he entered a lady's house, or he entered a house, and that there was a lady who had been washing her hair, and that he had walked behind her, and he'd put his hands out in front of her, that he hadn't touched her, and that she screamed, and that was that.
Do you remember what part of the house Mr. Mallory said this was, that this incident happened? When Mr. Mallory told you about a rehabilitation or experimental program, do you remember what he said that was about, why he had to go there?
Just that it's, a new program. We didn't really discuss any more than that.
Did he tell you what the program was for, though? Was it for alcohol, or just what he said it was for?
He never said it was for anything special that I can remember. Just a new rehabilitative program they were trying.
Do you recall discussing with the detectives other instances involving some difficulties that Mr. Mallory had in Maryland with certain other women?
Yeah, these were super popular. A lot of I remember teachers rocking these dresses when I was a kid in school. Like, she looks like a teacher, honestly.
The only other program was a situation where he had had a loving situation with a lady that had broken up.
And what did he say about that? Who was that person?
A woman.
Do you recall talking to the detectives about it was an ambassador's wife or something? Do you remember that?
Of course, I don't know if any of this is true.
We're just talking about
okay.
what he told you. Yeah.
Okay.
Yeah.
Okay. He had said it was. I don't know if it. I don't even remember at this moment. It was an ambassador. It was somebody. I don't know the word I used at this moment, but it was somebody in that kind of a capacity. And that they were divorced, I believe.
Do you recall telling the detectives that Mr. Mallory had indicated to you that he thought he saw this woman in Tampa, in the state of Florida, at one point?
Yes.
And where was it that he thought that he told you he thought he had seen her?
He said he thought he had seen her in a dancing in a bar.
Do you recall telling the detectives what kind of bar it was that he was in?
He said he thought it was in a like a topless bar or something like that.
Do you recall talking to the detectives about what Mr. Mallory had told you about his frequenting topless bars or nude bars?
Well, he said he did go to nude bars.
Do you remember him telling you why he did that?
Well, the reason that he gave me for why he went was because he had insomnia, and that was something that would be available. He might, he did.
Do you recall telling the detectives about Mr. Mallory being paranoid?
Yes.
And do you recall telling the detectives about Mr. Mallory being paranoid in reference to this woman from, I guess, the Washington, Maryland area, the diplomat's wife?
No, I don't believe that was.
Do you recall talking to the detectives about plastic surgery that Mr. Mallory said he either wanted to have or had? I don't remember which one it was.
He said he would like to have plastic surgery, yes.
And why did he tell you he wanted to have plastic surgery?
Because he would like to have his nose fixed and to have the top of his ear fixed.
And do you recall what you told the detectives about why Mr. Mallory told you he wanted to have that? Why he wanted to have his nose and ear fixed?
Because he felt like he was marked that he had a nose disfiguration.
Do you recall talking to the detectives about Mr. Mallory being apprehensive that people were following him and being paranoid about that?
Yes.
And do you recall talking to the detectives about Mr. Mallory's feelings of apprehension in reference to these women from up north, or the situation he had been with up north?
No.
Okay. Do you recall talking to the detectives about what Mr. Mallory told you about a roommate he had up north?
No.
recall talking to the detectives about what you perceived as two personalities that Mr. Mallory had?
Yes.
And do you recall what you told the detectives about the two personalities?
That he had one personality that was very easygoing, sweet, generous, always pleasant. And then he had another personality where he withdrew into himself.
Do you recall telling the detectives that when, we'll call it the second personality, when he withdrew into himself, that he would become difficult to deal with?
I made an assumption of when that might happen.
And do you recall telling the detectives that when he would be in the second personality, he would be quite paranoid?
I don't feel that quite paranoid is a proper...
Okay, do you remember what you told the detectives about that, about the second personality?
Well, that he was just, withdrew into himself and was a different kind of person.
Other than withdrawing into himself, what else did you tell the detectives about the second personality, if you recall?
No.
You don't recall?
I don't recall.
Do you recall telling the detective that Mr. Mallory had been incarcerated for 10 years? That he had told you that?
I don't understand the word incarcerated. I mean, because if that means...
In jail or prison?
Okay, no, I don't remember him telling me he'd been in jail. He told me he'd been in a rehabilitative program.
Okay. Do you recall telling them something about 10 years?
Yes.
And what was that in reference to?
The fact that he had been in this therapy program for 10 years.
Okay, so he was in the therapy program for 10
Well,
years? From what he told you?
Rehabilitative means therapy, I don't know.
Do you recall him telling you how old he was when he first went into the rehabilitative maintenance program?
In his late teens, I mean.
And do you recall whether he told you if this was as a result of or after the burglary situation with the woman?
It was because of.
It was because of that? Did Mr. Mallory ever tell you whether he went to court on that case and what happened in court?
Just that he went to court on it.
Did he ever tell you what the woman said that he did? Or what he believed the woman said he did?
Well, just that she screamed.
Did he ever tell you why she screamed?
I would imagine because he was there.
Do you recall talking to the detectives about Mr. Mallory being obsessed with washing himself?
No.
Or cleaning himself?
No.
Do you recall telling them something to the effect that he was a person who bathed often, wanted to bathe himself often?
You mean every day after work?
Yeah.
Yes, he bathed every day after work.
Do you recall what you told the detectives about what Mr. Mallory told you about that, why he was doing that?
Well, the same reason I guess anybody else would bathe every day after work. I don't know that he bathed every single day after work. I mean,
do you recall telling Detective Perzepa that Mr. Mallory believed he was being followed?
he sometimes felt like he was being followed, yes.
And do you recall why Mr. Mallory, what you told the detectives as to why Mr. Mallory believed?
Seeking justice coming through with a share. Thanks, guys.
That?
No.
Do you remember, putting aside the detectives for a moment, do you remember what Mr. Mallory may have told you about that?
No, other than just the fact that he felt like he was being followed.
Do you recall telling the detectives that he had a very strict habit of going home from work and showering, washing his hair, and changing his clothes because he felt that
This is the mother of Richard Mallory, the guy that's actually, the trial's actually about.
He was a person that had a body odor situation, and after working all day, he said he couldn't go out without showering, so I would be extremely surprised if he would go out in jeans. Do you remember saying that to the detectives?
I think that's an exaggeration of a person's daily routine.
Okay, but you said that to the detectives, right? Can you do that?
Those are probably my words, yes.
Do you recall talking to the detectives about Mr. Mallory's VCR tapes, magazines, things along that nature?
In regard to the fact that he had VCRs, yes?
Yeah, and magazines?
No.
Do you recall talking to the detectives about what types of tapes Mr. Mallory had?
He had all kinds of tapes.
Do you recall telling Detective Herzepa about certain pornographic tapes that Mr. Mallory had?
Certain pornographic tapes?
Yeah, he asked you and you said you were aware of that. Do you remember that?
Where that he had pornographic tapes?
Yeah.
Yes.
And magazines too, right?
No.
You don't remember that one? Do you recall talking to Detective Herzepa about Mr. Mallory's losing his security clearance?
Yes.
Do you remember what the reason was that you gave the detective as to why Mr. Mallory lost his security clearance?
No.
Do you recall talking to this Detective Herzepa about Mr. Mallory's drinking and how you were concerned about that?
We discussed his drinking.
Do you recall telling the detective that Mr. Mallory's personality, the two personalities we spoke about, would change when he would be drinking?
No.
Do you remember talking to the detectives about Mr. Mallory's...
People that I know I've talked about on here a lot because I come from a family with drunks and I drink myself, but people that change like that, which I've seen, and I have family that did that as well. Especially I had an uncle that would get real belligerent when he would drink. But people that do change like that, it's the worst, man. Like, I hate that. Like something clicks and the devil comes out.
Smoking marijuana.
Yes.
And do you recall what you told the detectives about Mr. Mallory's personality when he smoked marijuana?
Changing on the weed? He becomes evil on this guy. May be the devil. He smoke a little weed, he just becomes a rapist. Let's calm down. This guy, there's something wrong.
That I sometimes wondered if he smoked marijuana and made his personality change.
You damn weed.
Do you recall telling Detective Herzepa that I think the
It's the
question
blame
he
for
asked
all
was,
this.
how about his drinking? Didn't he drink? And you said, yeah, most of the time. Do you recall that?
No, I don't recall saying that.
Do you recall telling the detective that when you knew that Mr. Mallory had been drinking and smoking at the same time, he would be difficult to deal with?
No.
Do you recall
Devil's
talking to the
lettuce.
detectives about whether Mr. Mallory had male friends? I think they asked you quite well.
Well, you mean like whether he had friendship?
Do you recall telling him that Mr. Mallory did not have male friends?
Yes.
Do you recall telling, withdraw. Do you recall what you told Detective Frazeppa about whether Mr. Mallory believed he was physically able to handle himself from things that Mr. Mallory had told you?
I don't recall.
Do you recall telling the detective he believed he was physically able to handle himself? If anybody ever, tried to touch him, he would just go for the throat, with his hands and all this stuff?
I don't recall.
Don't remember that? Let me just have a moment, Your Honor.
Yes, sir.
Do you recall speaking to some of the attorneys, some prosecutors and defense attorneys in this case yesterday?
Yes.
Did you tell them anything about a reason why you may not remember all of the things you talked to Detective Frazeppa about?
Yes.
Do you recall what you told them?
I told him it was because of the fact that I had an accident a few years ago, and that because of it, I have some scar tissue, and that I have, sometimes there's memories that I don't have.
When you were talking to Detective Frazeppa, you recall some of that?
Oh, yeah.
Okay. Were you trying to be truthful with him?
Yes.
And when you were talking to the detective, were you trying to, as honestly as you could, answer all of his questions with regard to what he was asking about?
Mm-hmm.
I have nothing further.
In any type of crime or offense or do anything illegal?
I never saw him so much as get a speeding ticket when I was with him.
Nothing?
Nothing.
He was just a gentle, laid-back man, wasn't he?
Yes.
A gentle, laid-back man.
Yes.
For a period of time. Thank you, ma'am. Nothing further.
Your Honor, with the proffer, we would, I guess, ask Your Honor again to consider, reconsider.
You want to call the lady as a witness?
Only if we could discuss the subject matter, Your Honor.
Well, what subject matter are you going to discuss? I don't know what you want to tell the jury. We've been making a lot of discovery here, but what is it you want to use with that?
The background information relating to Mr. Mallory, to the prior incarceration record, to the maintenance program that the witness discussed, to his smoking marijuana, to the new cars, that type of
Any of this information known to the defendant?
What, Your Honor, heard maybe...
I don't know. As deal with reputation,
As Your Honor recalls, Ms. Wuornos testified that Mr. Mallory had made certain statements to her during their interaction.
Mr. Tanner, Mr. Moore?
I'd just like to address, and I think Mr. Lois has given you the appropriate case. The case says that if this witness could provide perhaps some reputation evidence as to the violence of this individual, or if she could provide testimony that Ms. Wuornos knew of prior acts of violence by this individual, it might perhaps be admissible, assuming this witness could even remember that. But certainly none of that has been proffered. As a matter of fact, the defense didn't even bother to ask the question. So under the law that they themselves have provided you, there's no basis for introducing this testimony.
Well, I'm just going to let them have the best hope and go with it. Whatever they see fit to do, fine with me. You ready to bring in the jury now?
Your Honor, before the jury comes in, we'd like to make an oral motion in limine that he not ask Ms. Davis about any prior alleged rehabilitation program. She has no personal knowledge of that. We're dealing with a deceased individual who can't defend himself, can't offer anything, and they're attempting to smear his reputation. There's no evidence whatever the defendant had any knowledge of any such reputation.
Then it does hold, you do too. We're bringing in the jury.
Your Honor, can we take a few minutes to confer?
I don't think we need it, sir. I'm ready to proceed. We jerk this jury around for 1 hour and 5 minutes. I think we're ready to proceed.
Your Honor, when the jury went out, our client was in the witness
Yeah, we need
box.
to-
Can we replace her?
Okay. Will you stand down and have a seat back over here, man? I think you'll be
They did bring her back up.
Your Honor, at this time, the defense has no further questions of Ms. Wuornos.
Ms. Wuornos, you may stand down.
Thank you.
What?
Judge, if you may have indulgence for a moment.
What is happening?
Please.
Your Honor, at this time, the defense would rest.
Hey, Salty, morning.
All right.
You're doing good.
Ladies and gentlemen, I need to confer with counsel. And then I'm going to give you some options.
All right, where are we going next? That was weird. What the fuck was that about Aileen? This guy's back. Lawrence Horzeppa returning for a moment here.
Thank you, Your Honor. Please, the court. Again, for the record, Deputy Horzeppa, would you state your name and your occupation?
Lawrence Horzeppa. I'm an investigator with the Volusia County Sheriff's Office assigned to the Major Case Unit.
And do you realize that you're having been placed under oath
Yes, sir.
several days ago carries over to your testimony here today?
Yes, sir.
All right, sir. On January the 16th, 1991, when you interviewed defendant Aileen Wuornos, can you tell the jury whether or not that entire interview from start to finish was videotaped?
Yes, it was.
And was there audio accompanying the videotape?
Yes, there was.
Can you tell the jury, please, how long that entire tape runs?
I believe a little over 3 hours.
Could you describe her demeanor throughout the 3.5 hour period?
She was.
Objection, Your Honor, beyond the scope.
Objection overruled. Go ahead and answer.
She was slightly nervous at first, then became relaxed during our interview and spoke freely to us.
Was she provided any material things to comfort her and calm her down, help her feel okay?
She was provided cigarettes, coffee, and a break anytime she needed it as far as the restroom was concerned.
Did you at any time intentionally cut her off and not let her explain anything she wanted to explain?
No, sir.
Objection, Your Honor, the tape speaks for itself.
Objection overruled.
No, sir.
Now, before the videotape came on, was she in the room with you before the recording began?
No, sir.
With every moment that she was in your presence that day, the statement was taken, videotape with the audio running?
That's correct.
Was your every word in action and her every word in action and that of Deputy Munster recorded on the audio videotape?
Yes, sir.
As well as that of her attorney, Mr. O'Neill?
Yes, sir.
Except she huddled with him outside the presence of the law enforcement officers and the camera briefly, didn't she?
Yes, sir. When he requested that, we shut the systems down.
He conferred privately without the deputies around, without the cameras.
That's correct.
Other than that, was every contact that you had, in fact, every contact you had with this woman, audio, video, recorded?
Leading, Your Honor, objection.
Rephrase your question.
Was there any record made of all of your contact with her on that day, January the 19th?
Yes, sir, it was all recorded.
Did you at any time that day or otherwise threaten to arrest Ty Moore and seek her prosecution if Aileen Wuornos didn't confess to this murder?
No, sir.
Your Honor, we would like the entire videotape marked for identification. I'm sorry, and Mr. DeMoore pointed out, I meant the interview was on the 16th of January, 1991, correct?
That's correct.
And if I said the 19th with the same answer, were you talking about the interview on the 16th?
That's correct, January 16th.
That's what my question is meant to address.
Yes, sir.
For identification.
And we received marked identification. Any further questions?
One last question. The item has just now been marked for identification. The entire videotape from start to finish, is that the videotape for a verified copy of the entire transaction between you and Aileen Wuornos with regard to her statements on January 16th, 1991?
Yes, sir.
No further questions, Your Honor. And that is exhibit
6 Y's, 6 Z's, and 7 A's.
6 times Y, Z, and A. Y, Z, A.
Detective Prezeppa, you remember testifying here the other day, 2 days ago or so?
Yes, sir.
You remember testifying that during the time you spent with Ms. Wuornos, she was rambling?
Yes, sir.
You remember testifying that she was covering many different topics?
Yes, sir.
You remember saying that she was bouncing around from things about her history to things about Mallory to other things?
That's correct.
You remember testifying that you asked her certain specific questions?
Yes, sir.
And you remember we went through a number of questions that I asked whether you asked her and that you indicated you did not ask her.
Trying to recall that, sir.
Okay, you don't remember me asking you about asking her what she meant by violent? You got
Yes,
my
sir.
thing, and you said you didn't ask her those questions.
Yes,
Remember that? Prior to your contact with Ms. Wuornos, she had spoken on the telephone with Ms. Moore. You were aware of that?
Yes, sir.
And you were aware of the fact that you've listened to the tapes you indicated?
Yes, sir.
To Ms. Moore's tapes of her conversation with Ms. Wuornos?
Yes, sir.
And you remember testifying that you're aware of the fact that Ms. Moore had indicated to Ms. Wuornos that law enforcement was coming down on her family?
She advised that they had been to see her, yes, sir.
And that she was concerned about that?
Yes, sir.
And that Ms. Moore's purpose was to get Ms. Wuornos to speak to law enforcement?
Yes, sir.
Nothing else, Your Honor. Thank you, Detective.
Yes, sir. For clarity, the question was, did you ever threaten Aileen Wuornos with the arrest of Ty Moore? Did you ever threaten Aileen Wuornos with the arrest of Ty Moore?
Thank you.
No, sir, I did not.
No further question, Your Honor.
Any further?
That's it, Judge.
Stand down and start
Your Honor, please
How
take
much of
rest.
this we got left?
All right, ladies and gentlemen, jury, it's necessary that we have conferred in this last recess is the best timing for you. With a recess for the weekend and the request that you
weekend.
report back at 10 a.m. on Monday. Just give you the process of what will be happening. I will be meeting with the council over the weekend and Monday for the record purposes. Prepare the instructions of the law will be given to you. After we prepare those, and you report at 10 o'clock, we will begin the closing argument of counsel.
Teresa,
After the closing argument,
you're on the wheel I'm getting ready to
the court will
spin.
instruct the law in the case to which you apply the facts that you've heard it from the witnesses and been sworn to testify before you. After the closing argument, you will deliberate, and that will take our Monday to its conclusion. And so this weekend, again, I remind you, if anyone's attempting to work with you or to discuss this case with you, you're to advise the court the proper remedy will be immediately initiated. You're not during the time of this or any recess to view the scene where any alleged offense may have occurred. You're not to listen to view any radio or television broadcast, telecast, the trial. not to discuss the case among yourselves or with any other person. You will not form or express an opinion on this matter until it's submitted to you for your verdict. With those instructions, the jury is in recess till 10 a.m. Monday morning next. Court's in recess until 9 a.m.
I'm interested to see what we got left here. All right, well, this is a long one. Closing arguments are, here we are. Closing arguments are heard in the case. Holy shit, we're near the end, my friends. Wait, what? Are we though? Oh, okay. Closing argument, verdict, penalty phase, penalty. Oh, there's a lot of penalty phase stuff. Oh, okay. Oh, then there's another closing arguments. This is kind of like the trial that I did in July, the murder trial here where I live. After we convicted him of first-degree murder, there was a penalty phase where there was witnesses from both sides that came up. From his side, folks from his past that were saying why you should take it easy and be lenient. It's interesting. Okay, we are getting into the nitty-gritty, but we're going to start out here with 2 hours and 13 minutes. Closing arguments. This looks like, is this from, I guess we'll see. Start her up. Well, first of all, we're going to do a wheel. Let's spin a wheel first. Hold on. Gonna spin a wheel. Gonna spin a wheel. Now, this wheel right here, again, this is a secret wheel. I make a lot of noise about the secret wheel. There's only one way to get on this wheel, and that's to go anytime I drop a new video over on the second channel, Wrestle Plunge. All you gotta do is give a like, leave a comment, and hopefully watch the video to completion. That is important as well. But for these things, what do you get? You get on a wheel for a possible free t-shirt from publiclybuzz.com. I got a lot of really cool merch over there. And right now, let's get this going. Let's see here. We had Pammy, real government name Tiff, Teresa, Ashy Snow, Pokemon, Catgrow, and Bassett Page all came through on this one. Again, I appreciate the hell out of that, guys. Let's see who wins a shirt. Ooh, Ashy Pokemon! You slipped right in there, right at the end. Holy shit, Pokemon wins a free t-shirt. Pokemon, hell yeah, I'll get with you. That's awesome. Fuck yeah. Nice. Nice. Congratulations. That's cool. I thought it was Ashy till the very end, and my God, holy crap. Snuck right in there.
I'm telling you like it is, baby.
Oh, shit. Here we go again.
Gotta do it, gotta do it.
Oh, man, I shot Marvin in the face.
Why the fuck you do that?
Why the fuck you do that? Boom, boom, congratulations. What's up, Strict 9? Get in here. Spinning and winning, yeah, spinning. We spinning and winning, we doing it. We doing it. We spinning and winning on a Sunday morning. I almost said a Monday morning. I don't even know what day it is. I don't even know what time of day it is. We live, babe, we live, girl. We here to do it, baby, baby. Okay, closing arguments. Let's go. Rock and roll. Boom. We'll see if we make it through all this. I'm not going to promise it, but we'll see. It's possible. I need to get that on there.
This stage of the case is making their final argument. The counsel for the defendant will have opening argument. Counsel for the state will have his opportunity for argument. And in conclusion, counsel for the defendant will have an opportunity to reply and rebuttal argument of counsel for the state. And the attorneys in making these arguments to you will be commenting upon the testimony that you have heard and the evidence that has been admitted and for your consideration. And they, as you, will be recalling the evidence in the case. Now, let me assure you they will not intentionally try to mislead you. However, if your recollection of the testimony differs from their memory, you must be guided by your own recollection of the testimony. Now, these final arguments, the attorneys, just as I instructed you on opening statements, are not to be considered by you as evidence of this cause or instruction of the law the court will give you at the conclusion. Nevertheless, these arguments are intended to help you to understand the contentions of each side, and I would request that you give them your closest attention. Mr. Miller?
Thank you. Members of the jury, you are here today having heard and considered over 2 weeks of testimony in this case. Your job now is about to begin. You are to discover the truth. But you are to discover the truth, and by the truth, we mean what happened on December 1st of 1989. You are not to determine what happened in June of 1990, or in July of 1990, or in November of 1990. You are to decide but one issue in this case, for there is only one issue before you. That is whether Aileen Wuornos felt that she had to take Richard Mallory's life on December 1st of 1989. I remind you of this, people, because in this case, unlike any other, so much of what you've heard has nothing to do with the death of Mr. Mallory. So much of what you've heard has nothing to do with December of 1989. So much of what you've heard has nothing to do with what Aileen Wuornos was thinking when she pulled the trigger in December of 1989. In order to do your jobs properly, you have to remind yourselves that there will be other juries, there will be other judges who will make determinations as to what happened 6 months to 1 year after Richard Mallory was killed. You must consider Richard Mallory and nothing else. And you must consider that tragic evening when Aileen Wuornos felt compelled to take Mr. Mallory's life in a dark, secluded area in the early morning hours. And as you consider the facts and the evidence that came from that stand as it applied to Richard Mallory, and as it applied to what happened in December of 1989, 3 simple truths will emerge. Aileen Wuornos is not guilty of premeditated first-degree murder. She is not guilty of felony murder. She is not guilty of robbery. Consider the witnesses that the state presented to you. You did hear a lot of testimony, and early on you heard some testimony that Richard Mallory was found in an isolated area and that several items were found near his car. Remember that Aileen Wuornos told you these things as well. None of that is in dispute. You heard that among those items were a half-empty vodka bottle, 2 glass tumblers that were put in a little area near the car. Aileen Wuornos told you how they got there. And she told you how the bottle got half-empty. You later learned that Smirnoff was Mr. Mallory's brand and that he had a habit of drinking a lot. And Ms. Wuornos told you this as well. You learned that Richard Mallory's pants were on when he was found.
Like, we got this dude to come up and do the closings. He's a real master. We brought in a real killer over here.
But that his belt was adjusted to one side approximately 4 to 6 inches, and that he had nothing on underneath his pants. And you will recall Aileen Wuornos told you how that happened as well. Later, in the first week,
very
you
boring
were told
already.
how Mr. Mallory died. You were told that he was shot to death. And you heard this originally from Dr. Botting, and you may recall Dr. Botting. He was kind of a heavy-set, white-haired gentleman that testified in the first week. Dr. Botting performed what he termed an autopsy on Mr. Mallory, but you might recall that Dr. Botting didn't draw a diagram to show you where Mr. Mallory had been injured. He didn't estimate the size of Mr. Mallory, and he didn't do any tests to determine whether or not Mr. Mallory had sexual activity before he was killed. Now, I call your attention to those things because you will recall you heard from other medical examiners and other experts who told you that those kind of things were standard procedures for a medical examiner. And you should also recall, and perhaps more importantly recall, what Dr. Botting could not tell you. He could not tell you how far away Richard Mallory was when he was shot. He could not tell you the sequence of those shots. He could not tell you, most importantly, what was happening before Richard Mallory was shot. Simply put, Dr. Bottom could tell you nothing about self-defense. He could tell you nothing to assist you in determining the only issue which exists in this case. So what other evidence did you get? Well, you learned how Mr. Mallory's car was found. You heard that it was found in an isolated area, and again, Lee Wuornos told you where this car was left. You learned that a search of local nude bars and strip joints was conducted to find Mr. Mallory. You also learned that a stripper named Chastity Marcus had been with Mr. Mallory shortly before his death, and that she was at one point arrested for the killing. You learned that Mr. Mallory was known to smoke pot, just as Lee Wuornos told you he had been doing on that fateful evening. Eventually, you were given some technical evidence. You were shown bullets. You were shown a gun.
Yeah, did they save him exclusively for the closing? They're like, all right, we need to bore them to death. We're going to take 2 hours. Jesus.
You were shown this gun. And you will also recall that Lee Wuornos not only told you that this was indeed her gun, and that yes, she had shot Richard Mallory with it, she told the police where to find it. As the trial moved on, you heard a great deal of testimony, and this is particularly true of last week, about incidents which began 6 months after Mr. Mallory was killed. You also heard the testimony of a certain Bobby Lee Copus. He was the rather heavy-set truck driver that came in, and he claimed to have met Lee Wuornos nearly a year after Mr. Mallory had been killed. When considering Bobby Lee Copus, first ask yourselves whether Lee Wuornos' behavior in November of 1990 had anything at all to do with what was going through her mind in December of 1989. Then ask yourselves, was Bobby Lee Copus telling you the truth? Bobby Lee Copus, who testified that he saw a gun in Ms. Wuornos' purse, and he was a small caliber firearm. And he knew it was a small caliber firearm because it was a tiny little gun, like the one his wife carried. I ask you to handle this weapon. Look at it carefully, and you determine. Was Bobby Lee Copus telling you the truth? A man who remembers verbatim what a complete stranger told him a year before, but forgot to tell the police about it? The answer is plain. Lee Wuornos was telling you the truth when she said she had never seen Bobby Lee Copus. So after 2 weeks of testimony and 2 weeks of evidence, the state asked you to determine the issue in this case. Did Lee Wuornos act in self-defense? Well, they leave you with essentially 2 witnesses to decide this issue. Those 2 witnesses are Tyra Moore and Larry Perzetto. First, you will recall Tyra Moore. She was Lee's former lover. She testified in the first plea. Rather heavy-set woman, very short hair, and stoic in her appearance. And what the state wanted you to hear from Tyra Moore was that Lee Wuornos had come to her in December of 1989 and told her she'd killed a man. And you did hear that from Tyra Moore. She said it over and over again. But what else did Tyra Moore tell you? And what were her motivations for doing so? First of all, recall that Tyra Moore was a suspect. She had wrecked a car and been seen in that car, and as a result, a picture of her appeared on the TV. You must remember that Tyra Moore had known for over a year that Lee Wuornos had shot Richard Mallory. And she didn't leave, and she didn't call the police. And you have to ask yourselves, what does that tell you? Either Lee was telling you the truth, and Tyra Moore really did know that it was in self-defense, or Tyra Moore just didn't care. But Tyra Moore did start to care, only when she saw that this might affect her.
Yeah, I don't think he's appeared at all till now.
When she saw that she might catch some heat, she left. And she went half a country away, leaving Lee Wuornos behind. And eventually Tyra Moore was found half a country away in the state of Pennsylvania. And eventually law enforcement officers talked to her about this case. And they asked her if she'd do them a little favor. She was brought down to the state of Florida. She was put up in a hotel room with money from our government. Her meals were paid for, her cigarettes were paid for, her room was paid for, and all she had to do was write Lee a little note. Write Lee a little note and have Lee call her. And then Tyra Moore could fully implicate Lee Wuornos. And so Tyra pulled Lee's emotional strings during 11 phone calls in January of 1991. And Lee Wuornos will do what Tyra Moore wants because Lee Wuornos loves Tyra Moore. Lee Wuornos would do anything for Tyra Moore. Lee Wuornos would die for Tyra Moore. And Tyra, of course, knew this, and she knew it well, because Lee had opened herself up to Tyra and told her this on numerous occasions. So in January of 1991, Tyra Moore lied to her lover, and she cried to her lover, and ultimately she threatened suicide to her lover. Until Lee Wuornos, terrified that Ty would be arrested, or perhaps worse, gave Larry Horzaba and Bruce Munster and Ty Moore exactly what they wanted. And Ty went back up north. It wasn't long after Ty went up north that she got a friendly little phone call from Bruce Munster, the Marion County Sheriff's Office. She was told at that time, well, if she wanted to, she could share his lawyer. She could make a little money on this thing. How much money? You heard the figure $50,000, didn't you? And while it is true, Tyra told you she hasn't gotten any money for her story yet, certainly she was considering it. She was considering it when she called her law enforcement friend Rose Gianzani on the phone and talked to her about it and asked her whether she should get a lawyer. And consider that relationship, the relationship between Rose Gianzani and Tyra Moore. Rose Gianzani, a woman who was assigned to watch over a potential murder suspect for 4 days and gave her anything she wanted, paid for it with government money, and who's been in regular contact with this woman long after her job has required her to. You will recall Rose Gianzani goes out to dinner with Ty, and she chauffeurs her from the airport. And she brought her here to this courtroom, and she tried to sit in the courtroom while Ty testified. Nonetheless, Tyra Moore, as a witness, with her obvious reasons to try to please law enforcement and the state with her testimony, she did offer some valuable insights into this case. First of all, you will recall Ty told you that in 4.5 years of living every day with Aileen Wuornos, not once did Aileen raise a hand at her. Not once did she lay a hand on her. She said they already knew. More importantly, she told you not once did Lee strike anyone else. And you'll recall the question to the state attorney, well, wasn't there a time where there was a bar fight or something? No. And what did she tell you about Lee's drinking? Yes, Lee drank a lot. And she did drink to become more outgoing. And in fact, that's what happened when Lee drank. She did become more outgoing. That's the testimony of Tyra Moore. It is also the testimony of Lee Wuornos. Another thing that Tyra Moore told you, she kind of told you in a backwards way. You'll recall the state was asking Tyra Moore some questions. Well, when Lee came home in December of 1989 with Richard Mallory's Cadillac, was her speech all slurred? Was she stumbling around? No, no. But on cross-examination, one simple question. Was she intoxicated? Was she drunk? Yes. Again, Lee Wuornos told you this as well. And it wasn't long after Lee brought that Cadillac home that Lee tried to tell Ty about what had happened and how she had ended up with that car. And when Lee Wuornos went to Tyra Moore and told Tyra, I really need to tell you something. When Lee Wuornos confided in her only real friend in the world that she needed to talk to her, she needed to tell her something, something horrible had happened, Tyra's response was very simple. I don't want to hear about it. Just as Ty didn't want to hear about Lee's job because you'll recall Ty said she was jealous when Lee went out with other men. You'll also recall that Tyra wasn't so jealous that she wasn't willing to spend Lee's money. She just didn't want to hear where Lee got it. She didn't want to hear how Lee suffered to get it. She didn't want to hear how Lee was raped and beaten on numerous times. Tyra Moore didn't want to hear it. And the words, I don't want to hear it, should remind you of the other key state witness in this case, Detective Larry Wuornos. You'll recall that Mr. Wuornos took that witness stand on 3 separate occasions. And it was he who, with Detective Munster, talked to Lee for 3 hours a year ago. And it was that tape that you saw in this courtroom. Well, now you have the task of deciding Mr. Wuornos' credibility as a witness. And in doing so, consider this simple question. Why did Larry Wuornos have to take that witness stand and tell you what Lee Wuornos had told him when you could see it for yourself? The answer to that question is simple. Larry Wuornos put together what he called a synopsis of what happened to Mr. Mallory and what Lee had told him about it in January of 1991. And when he did this, he was very, very careful to extract anything which lets you know, number one, why Lee was talking to him in the first place, and number two, and far more importantly, why Lee shot Richard Mallory in 1989. Larry Wuornos did not want to know the answer to the only question which is important in this case. And that is, why did Lee Wuornos feel that she had to shoot Mr. Mallory? And it's just as obvious, should be just as obvious, as to why Larry Wuornos did not want you to know the answer to this question. The answer is simple. Because in spite of what he tried to tell you, the tape speaks for itself. And Lee Wuornos said over and over and over again in January of 1991 and again in January of 1992 that she defended herself in December of 1989. But Larry Wuornos, just like Ty, didn't want to hear about it. Fortunately, through the cross-examination that you heard in this case, Mr. Wuornos was exposed. Consider, if you will, his original testimony. You will recall that Mr. Wuornos had some notes right here on this stand. And you will recall that Mr. Nolas came and got these notes. And he looked at them. We had a few minutes over by the table. And when he was questioned again about those notes, you will recall that there was a reference in the typewritten notes which he had prepared to help him testify. In the typewritten notes, there was a reference where Lee Wuornos had said that this man was hurting her. And Larry Wuornos wrote in his own handwriting off to the side 2 words which explained Larry Wuornos to each and every one of you. And those 2 words were, don't use. And don't use, people, means don't let the jury hear. Don't let you hear. You who are to decide what really happened in this case. According to Mr. Horzepa, you are to hear that Lee Wuornos wanted to talk and wanted to talk to investigators about Richard Mallory's death. But you're not to hear why. You are to hear that Lee Wuornos occasionally got
Someone coughing or the dog barking?
confused in those 3 hours of statements. But you're not to hear why. You are to hear that Richard Mallory was shot by Ms. Wuornos, but you are not to hear why. And why is the only issue in this case. You will remember Mr. Nolas asked Mr. Horzepa about this tendency of his on the stand. He asked Mr. Horzepa, why didn't you or Mr. Munster ever ask why Lee felt her life was in danger? Why didn't you ever ask what Mr. Mallory was doing to her? And Mr. Horzepa's response was, well, I wanted to let her talk. I didn't want to interrupt her. I didn't want to put words in her mouth. Well, remember these statements from the tape. At one point, Lee Wuornos saying, quote, he's hugging and kissing on me and all this, and then he starts...
No, it doesn't. It just says closing arguments are heard in the case.
You know, pushing me down, and I said, wait a minute, get cool. You don't have to get... And she's cut off by Bruce Munster, who interrupts her to say bye-bye to someone. But Lee continues, you don't have to get rough, you know. And Horzepa's next response, does he ask what...
Like, I'm imagining, I don't think I've ever seen, isn't it always the state that starts the closing? But I could be wrong. It could be, if I'm not mistaken, the one I saw in real life here in West Virginia, they decided, like, if you want to go first, you can, or something. But I'm not.
Rough means?
And honestly, the way he's talking, I've been confused as well, because at points I'm like, oh, is he on her side? And I'm like, wait, no, I don't think he is.
No, he says, well, where exactly were you sitting in the car? Lee continued, he's getting really heavy with me. He's starting to get violent with me. We're fighting a little bit. Larry Horzepa, well, what kind of purse did you have? Later, Lee states that Mr. Mallory had not undressed and that she had said, why didn't you take your clothes off? My God, it hurt to do that. Then he got pissed, calling me. He said, fuck you, baby, I'm gonna screw you right here and now. And Horzepa responds with yet another question about where are they seated in the car. Did he give Lee Wuornos an opportunity to talk? Or did he do everything he could to keep her from talking about
a
the
teammate,
issue
right?
that
It sounds like this is from the defense.
most in this case. A final time, Lee Wuornos stated how Mr. Mallory kept coming at her and coming at her, even after he'd been shot. And probably better than something that gives you better insight into Mr. Horzepa than anything else, as you will recall his answer to that statement on the tape. He's coming out to get you. He already told me that. Whereupon he moves on to another issue. Is Larry Horzepa a man who wants you to hear everything? Or is he a man who in January 1991, and again in January of 1992, doesn't want anybody to hear what Richard Mallory was doing to Lee Wuornos? Is this a man who wants you to know the truth about what happened? Remember his testimony from the witness stand. Mr. Tanner asks, how long did she say she had the gun? Mr. Horzepa's response, 2 days. What was the real answer? You saw it. I don't know. Might have been a couple of months, only a couple of months before, I think. I might have got the gun just then. I can't remember, like 2 days before or something, because I can't remember. It's a long time. Was that an honest answer that Mr. Horzepa gave you? You decide. Question by Mr. Tanner. Did Lee ever explain to you a rape by Mr. Mallory? Answer by Mr. Horzepa. No. What was the real answer? Well, she did say he pushed her. She did say he hurt her. She said he kept coming at her. He physically abused her. He got rough with her. He got violent with her. And when she complained of being hurt, he shut her up and said, "Fuck you, I'm going to give it to you now." Is that a rape? Can the answer to that question be no? I submit to you, Mr. Horzepa cannot truthfully tell you she did not say she was being raped. He may truthfully tell you she didn't say that word. He didn't want to hear it. And Ty didn't want to hear it. You, however, have heard it. And you heard a nervous and confused Lee Wuornos tell you as best she could the rest of the story. A story which was so horrifying, it doesn't take a genius to see why she might not be willing to relate some of those details to a couple of unsympathetic detectives. Officers who didn't want to hear it. Lee Wuornos told you she would do anything for Tyler Moore. And when she met Larry Horzepa and Bruce Munster at Tyra's urging, Lee Wuornos was clearly not concerned with herself. You can look at that tape and tell that. The state would have you believe that Ms. Wuornos somehow was trying to say that she had killed this man and that Tyra had nothing to do with it, but was lying to you on all the important stuff. Remember Lee Wuornos saying in that tape, "I deserve to die." What was her motivation for telling these officers that she'd been assaulted, she'd been attacked, she was defending herself? She wasn't caring about herself in January of 1991. She was caring about Tyler Moore. Despite the efforts of Mr. Horzepa, she was able to tell you as best she could on that day that she was being attacked. And later in this courtroom, Lee Wuornos may have been confused on that witness stand. She may have been rattled by the skillful cross-examination of Mr. Tanner. She told you the truth. And if at times she seemed angry at Mr. Tanner's relentless cross-examination, don't forget that Mr. Tanner is here before you, asking you to sentence her to death.
This guy's a ghost. He is a ghost.
It's not going to be long now before you're going to have to go into that jury room and make a very difficult and important decision. It will be difficult for you to do that and concentrate only on Richard Mallory, because you spent at least half your time in the last 2 weeks listening to things that had nothing to do with Richard Mallory. And as you consider those other things, those things which began in late May and early June of 1990, 6 months after Mr. Mallory was killed, think about these facts. Richard Mallory was shot in late 1989. Lee Wuornos had been a prostitute for some 17 years prior to that date. And while she'd been raped and beaten before, it wasn't until a drunken stone Richard Mallory hurt Lee, degraded Lee, and ultimately tortured Lee that Lee took the action that she did. It was only as she lay naked in a strange car in a dark, secluded place after having undergone unbearable torture that she finally took a life to defend herself. You don't know, people, what such an experience did to Lee's mind, or whether she could ever be the same again. You do know, however, that she continued to be a prostitute. It's the only work that she knew. And she continued to bring money to Tyler Moore. And she continued to go out on the road at least 3 times a week, several men on each of those days. And you know, therefore, that Lee Wuornos had sex with dozens of men in the next 6 months that followed. And you also know from the testimony that there were no incidents. And you also know that something happened again when she met David Spears in June of 1990. Maybe something snapped in Lee after that. Maybe she simply couldn't respond to anything normally again. Those difficult questions are not for you to decide. Those difficult questions are for other juries and other judges. Your job is much simpler because the evidence in this case is much clearer. Far from being the predator Mr. Tanner described in his opening statement, Lee Wuornos was a victim. She was the victim of a brutal attack, a tortuous attack at the hands of Richard Mallory in December of 1989. A violent attack which Mr. Horzeva did his best to keep from you. Think about the evidence that you've heard in the last 2 weeks. You will realize that you have not heard a single word suggesting that Aileen Wuornos robbed anyone. You have not heard a single word suggesting that Aileen Wuornos committed felony murder. You have not heard a single word suggesting to you that she shot Mr. Mallory with premeditation. When you consider the evidence of Aileen Wuornos' intent in December of 1989, there's only one conclusion. For all of the evidence suggests that she did nothing but defend herself. The evidence is all in. You've heard it. You've heard all of it. Follow that evidence to where it leads to one inescapable conclusion. And find Lee Wuornos guilty. Thank you.
First, I want to thank you. It's been a
Oh,
long
here
2
we
weeks.
go.
I know
Okay.
at times you thought your time.
I thought this guy was going to be up here for 2 hours himself, and I was like, oh my God. Okay, so he was 30 minutes, so we still have quite a while with this douchebag, so.
Was wasted and wondered why it seemed to move in slow motion. I can assure you that all of us, particularly the judge, but certainly counsel from both sides, have been moving this case as rapidly as we could and can. I can also tell you that all of us, including the judge, have worked through the weekends on this case, and we've tried to minimize wasted time. I don't think that jury service is any less important than service in the armed services. Certainly no less important than voting. And time you've given, time you will give, the part of yourselves that you will give as you deliberate and consider are something for us to be proud of as a nation, as a country, as a system. And it's one of the areas where perhaps our country does exceed in value of human dignity and value of right and value of protecting the accused and value of requiring the government to prove its case, not just say it. The value of all that we hold dear is typified and exemplified by what you've been and are now a part of. And I think from all of our hearts, we thank you for what you're doing. This is the only opportunity I'll have to talk to you until this case is totally over, and then only if you choose. And this is the only opportunity I have to argue. As you know, during jury selections, we didn't argue. During opening statement, we made a statement as to what we thought you could expect. And then finally get to the final stage of the case where the lawyers offer, I think, what we call argument. I'm not sure I like this part of the case, or ever have. But they aren't going to change the system because of the way I feel about it. I would prefer an open exchange. kind of a forum. Let the jurors ask questions, let the lawyers answer as best they could, and the judge intercede. But that's not the way we do it. So you're going to be stuck with me for about maybe 30 or 40 minutes, and I will try not to insult your intelligence, not to bore you with things that you already know very well. Try to point out what we believe the evidence has revealed in this case. First, let me tell you, you're going to receive jury instructions from the court, and lawyers on either side are not going to instruct you on the law. We will mention the law to you from time to time. The lawyer's argument is not evidence. In other words, what I say is not evidence. So what Mr. Knowles or part of that, Ms. Jenkins or Mr. Miller's team say is not evidence. The only evidence comes from the witness stand or from exhibits that have been offered. You should not decide this case on sympathy. Not sympathy for Mr. Mallory, and certainly not on sympathy for the accused. You're to decide on facts and on the evidence before you. Reasonable doubt. We discussed that a lot during jury selection. Listen to the judge's instructions. Reasonable doubt is not some mystical, hard to understand concept, but it certainly doesn't put a burden on the state to prove everything beyond any doubt, always. Matters that are subject to human beings cannot be proven beyond all doubt. There is no proof, virtually, of anything subject to human interaction that I would say is proof or provable beyond all doubt, especially when it comes to the matter of a crime unwitnessed by anyone except the two people, the victim and the attacker. Premeditation. Some of you may have had, and may still have in your mind, the idea that premeditation is long-range planning, conspiracy-type things, the type of thing that would take days or weeks or even hours, perhaps at the least. I'd ask you again, listen to the judge's instructions on premeditation. He will instruct you, in effect, that premeditation is simply carried out of act with an attempt, with an opportunity to reflect upon the action. It may only be the time between the picking up of the firearm and the firing it. Or it may only be between the first and the second shot. Surely by the third shot. Certainly by the fourth shot. Determined intent to kill. You'll hear about felony murder. Murders committed in the perpetration, in this case, of a robbery. You'll hear His Honor tell you that. If that's proven beyond a reasonable doubt, that's first-degree murder, Florida. He'll also talk to you about premeditated murder. If that's proven beyond a reasonable doubt, that also is first-degree murder. You will hear about justifiable and excusable homicide. And the way the instructions are framed and the way they are in every criminal case, you will hear Mr. Mallory's name. As Mr. Mallory is doing this and she did that, that sort of thing. That doesn't mean the judge has determined anything with regard to the facts, except their version of the case would support an instruction of that nature. It doesn't mean that their version is true. It doesn't mean that the judge has accepted either side. He is as neutral, he is more neutral than anyone in this room. Anything that may have happened during the trial, we had all the numerous objections by both sides and the interaction between lawyers, that's really not part of the case. Sometimes a hard-fought battle over evidentiary matters, sometimes a hard-fought battle over legal theories, and the judge has to rule upon it. The evidence that came from that witness stand, not what the lawyers are doing or not doing, is what you base your verdict upon. Not the performance, not whether you do or don't like one side or the other. And none of us would want you to give that any weight at all. The verdict form. You will receive two. One deals with robbery. And I believe in its final form it has 6 options.
Yo, Ember, morning.
It would be guilty of armed robbery.
I'm going to go to the bathroom, guys. I'll be right back.
Guilty of robbery of a deadly weapon but without a firearm. Guilty of robbery without a firearm or deadly weapon. Guilty of robbery without a weapon.
Right back. Thanks everyone for hanging out. Appreciate it.
Theft.
Getting close
We're
to
not
ending her.
guilty. We said, well, why do we get all these verdicts? It's a unique creation of the law, American, perhaps English jurisprudence as well, but that when a person is charged, let's say murder in the first degree or robbery, they're also charged with everything within that charge. Perhaps the murder is a little easier to understand. The potential possible verdicts are guilty of murder in the first degree, premeditated, and felony murder as charged, or guilty of only first degree premeditated murder. Kind of cringe at the word only, certainly only in common parlance would be inappropriate, but under the law we're trying to distinguish. Guilty of first degree felony murder, guilty of second degree murder, guilty of second degree murder with a firearm, third degree murder with a firearm, manslaughter with a firearm, and not guilty. So when you see those, don't be confused. They will be kind of in line form. There will be a place to check and a place for your foreperson to sign. You only check one on each verdict form. I can tell you throughout our argument, and our position will be that you should check the one at the top. It remains in the form it was when we had it rough, and that is guilty of murder in the first degree, both premeditated and felony murder, and also guilty of robbery with a firearm. Aileen Wuornos has been portrayed as a victim by the defense. She's not a victim in any sense of the word. She's not a victim because she's a prostitute. She has chosen to be a prostitute. Her reasons, ultimately given, was when she first started out, apparently a pretty young woman, was that she only made about 75 cents an hour working, but she could make $60 to $100 at a time for sex. And she learned very quickly that that was, for her, a preferred way to make a living. And that preference, that choice is carried on throughout her lifetime. This is not a victim prostitute. This is not a child wandering the streets with no choice. This is a grown woman, a healthy grown woman, with the capability of making an honest living if she wants to. She has chosen not to. She is not a victim. She indicated she likes sex. There's nothing wrong with that. But that's one of the reasons she was out there. She tried to push it off on the men, something to the effect that, well, they would keep their pants on and keep their wallets in their pocket. We wouldn't be out here. I guess drug dealers could say the same thing. If people wouldn't buy drugs, they wouldn't be dealing drugs. Therefore, we should excuse them. It's really not their fault. They're victims because people want to buy their product.
Objection, Your Honor.
Sustained.
Request the period of instruction, Your Honor.
Your disregard, last comment.
In that vein, let's go back to where we both started. In the defense case, you were told by Ms. Jenkins, essentially that night, Aileen Wuornos was hitchhiking, but she was afraid and hiding. Now, what was she afraid of? This is what she did for a living. This is where she chose to work. She chose to work the highways, and she wanted people to pick her up. Where is this aura of fear that she's hiding under the underpass and doesn't know what to do because she's on the highway stranded? And an automobile stopped and it frightened her. Well, I don't know that you have to be a prostitute hitchhiking. Any hitchhiker usually is delighted when they see the car stop. And I submit she was delighted when she saw the car stop. It was heading the direction she wanted to go, and she found it had a lone white male in it. That is who she preferred to ride with. She got in, and she headed to Daytona. Ms. Jenkins said that this woman had been beaten and raped repeatedly, and yet Tyra Moore said not once in 4.5 years they lived together did she ever come home and say she'd been beaten or raped. Ever. It just didn't happen. That she had, in the distant past, been beat up pretty good, apparently, one time, if she's telling the truth. But in the past 4.5 years, there's not been any physical assaults upon her, any beatings or rapings. None reported to anyone. Certainly not to her best friend. And if you're going to report that to anyone, you report that surely to no one else, to your best friend. She said that, Ms. Jenkins said that time and time again, Aileen Wuornos was not paid. Well, that may have been true. Maybe sometimes she wasn't paid. Instead, that Mallory told her to disrobe, and he wanted her to take her clothes off, but we've learned even from her own testimony that it was her policy to take the clothes off. And then they went on to say that after the alleged assault, that she went home and told Ty Moore basically the facts of being raped, sexually assaulted, and the various other very unpleasant things that you heard in the courtroom. But Ty said, well, I don't want to hear any more. But Ty was very supportive. Well, that's not supported by anything at all in this courtroom in the way of evidence except the statement of Aileen Wuornos. Everyone else's testimony is absolute to the contrary. She said, back to Ms. Jenkins in her opening statement, that Aileen Wuornos was really drunk royal, I think. But we heard Aileen Wuornos on the stand say that she had one mixed drink, and then Miss Mallory bought her a 6-pack of beer. And as over the next 5 hours, she drank it. She never even said she completed drinking the 6-pack of beer. Apparently, she had at least one left, if not more, because she had one to drink after she killed him. Sat on the car and drank the beer. That is not a person royally drunk out of their mind. Going to Mr. Miller's statement a few moments ago before lunch, and I want to address that directly before I move into some things I would like to point out to you. He began telling you that this was unlike any other case. Well, every case is different, but it's not unusual to have similar fact evidence in a case where there's evidence of other matters that are relevant material brought up in the trial for the substantive offense.
Objection, Your Honor.
Overruled.
And so there's nothing extraordinarily unique about what's happened here in this courtroom. I think probably the most unique thing is the woman in this circumstance. That's probably the most unique twist of the whole case. Because this woman said about a pattern of behavior that is unique. You were told by Ms. Miller that other juries in other cases would render verdicts on the other killings, and that's entirely true. You are not here to find her guilty or innocent with regard to the other killings. The only verdict that you're going to be asked to render would be that regarding Mr. Mallory. But at the same time, it doesn't mean you should not fully face your responsibility. I implore you, and I don't think that you would, but don't even think, well, someone else will do it. This is your duty today. I trust you will face that with the courage and the determination that it's going to require. You were also told, regrettably, I think, as far as I was concerned, by Mr. Miller, that your decision had something to do with whether she lived or died, and that whether you'd sentenced her to death by your verdict. That is not where we are in the case at all. This case is divided into two portions, bifurcated. Legally, we have chosen in Florida to separate guilt or innocence and the evidence concerning that. And if a verdict of first-degree murder is reached, then what penalty? But under no circumstances does the jury sentence anyone.
Objection, Your Honor.
Overruled.
Judge is the only one that sentences people in this courtroom.
Objection, Your Honor. Please reserve argument on the issue, Judge.
Be reserved.
Your Honor, I thought we had an agreement there would not be objections. They were all reserved, and that he would interrupt not during the trial. Of my closing, we didn't interrupt them.
We did have an agreement, Your Honor.
You sure did.
I've been touching on what I thought to be the most serious. And Mr. Tanner, apologize for interrupting the flow. We simply wanted to reserve argument.
You may proceed.
So penalty should not even be in your vocabulary, let alone in your mind, at the time to decide guilt or innocence, as far as we are at this point. Then Mr. Miller said that all of these other cases had absolutely nothing to do with the murder of Richard Mallory. That's incredible. That's incredible. Under the law, and under the facts, and the circumstances of this case. Similar fact evidence that is evidence of other crimes is relevant and material and properly and legally should be considered when ruled admissible by the court in criminal cases and even in civil cases. The case involving Mr. Mallory is a case on trial. This is the only case in which you are to determine guilt or innocence. But with regard to the second victim, Mr. Spears, third, Mr. Cascade, fourth, Peter Sims, fifth, Troy Burris, Dick Humphreys, the last, Walter and Antonio, and their automobiles, and the locations of where the bodies were found and where the cars were found. It's all relevant and material key issues in this case. Key issues, and instruction was read to you. I know it was a while ago. You'll hear, I think, the same or substantially the same instruction again before you go to the jury room. Basically indicates that similar fact evidence, that evidence of other crimes, when it's relevant to prove identity, opportunity, preparation, plan, common scheme or plan, pattern of criminality, intent or motive. In this case, we submit the absence of self-defense is relevant. That's relevant. It's relevant to what she did to Mr. Mallory. John, may I move this one a little closer? Can you see on that line? Richard Mallory was killed in December 1st, precisely. 11 miles from the downtown Daytona Beach area. He was 51 years old. David Spears, killed in June, 112 miles. Charles Cascade, June, 94 miles from Daytona. Peter Sims, reported missing in June. The body never recovered. This is the one she said she left in Georgia. Troy Burris, the sausage man, where she identified him by his vehicle August the 4th, 1990, 64 miles from Daytona. Mr. Humphreys, who was the HRS man, September 1990, 68 miles.
Made some coffee.
Walter Antonio, November, 147 miles. What do these men have in common?
I ain't made or drink coffee in a long time. I used to drink it.
All of them were white males between the ages of 39, 60 years old. They're all traveling major thoroughfares in Florida. They're all traveling alone. Each of them made one fatal mistake. They picked up Aileen Wuornos. In each of those cases, she propositioned them for sex. And she ultimately killed them all in isolated areas where there would be no witnesses. She shot every one of them in the torso. couple she also shot in the head. Multiple gunshot wounds, all from a .22 caliber hollow point. You heard the bullets described over and over again, virtually the same bullets. Same pistol as had been by her. Every one of them's property was stolen and their vehicle was taken. And the vehicle was wiped clean in the case of Mr. Mallory, Mr. Spears. Mr. Cascade's vehicle was stripped, was on the side of the highway before the police were able to do much with it. Peter Simmons, that was the one that turned over on 4th of July, and both of the women were in that case, in that car. Both the women were riding around in that car. I say both women, Tyra Moore and Ms. Wuornos. And that's the vehicle in which her Aileen Wuornos' bloody handprint was found. The other 3 vehicles were all wiped clean again. The license plate was removed on 5 of the 7 vehicles. All the vehicles were left abandoned, and they were left abandoned in a range of from 12 to 170 miles. Finally, the property of 3 of the 5 men was found in her mini warehouse. This evidence demonstrates a pattern and a method of criminality, an intent and plan to carry out robberies and murders on the highways of the state of Florida by this woman. And she had picked a selected target type individual to kill.
Your Honor, if we may reserve argument from this.
In our opening, I told you that on November the 30th, 1989, when 51-year-old Richard Mallory turned east onto I-4, he didn't know that he was living the last 10 hours of his life. He didn't know that in less than 10 hours he'd be robbed and left to rot in the woods. Of course, he didn't know he was about to pick up this woman. Nor did he know that for whatever reason,
maybe not this woman, but
she had begun to change her course of conduct, as far as we know, to a lethal and deadly pattern that would be reenacted over the next year 7 times. Her appetite to control men, and that's what most prostitutes are about. Besides money, it's control. That's tremendous control. Take all that a man has.
Your Honor, objection to.
I'm writing it down, sir. Look for it with the stipulation of the party.
To take all that a man has, physically, some say spiritually, is tremendous and almost absolute control. There's only one thing left. There's only one thing left, and that's to kill. You can't have much more than all the person, except their life. And that's what she wanted, and that's what she took. The evidence. Let's look at Dr. Bodding's evidence. And let's look at what his testimony showed us. Would a chart or drawing of Mr. Mallory's body told you any more than this shirt? This is the shirt he was wearing when she killed him. As best we can reconstruct from the shirt, the dead man, and her testimony, her various stories, is that he was sitting in the car, behind the wheel. There's no question about that. We also know that a bullet, perhaps the first bullet, and that coincides with her testimony, by the way, in her stories, entered in the rear of the shirt, rear right arm of the in the shoulder, went through the armpit and on into the chest. That's not indicative of a man on his knees over the top of an attacking woman. That's indicative of a man either with his hands on the wheel, and we will never know. We will never know all that occurred and the evidence that she left behind. Or a man shying back, but we don't have a man on his knees over a victim. It's not there. The evidence disproves that. The track of bullets. No way for us to know what order. We can only go from what she said, plus the evidence of the autopsy here, plus her common sense.
Son of a bitch!
But if he did, in fact, say,
I hate him.
Oh,
Son of a bitch!
Shot, as she said, and she said she thought she shot him in the side from outside the automobile, then that was probably the first shot. And then perhaps a second shot in the vehicle up in and through the neck. From the neck up was so decomposed, there was no track of a bullet discernible. So there was a definite track of a bullet from within, and it was horizontal, across the body, not up and back. And then there are the other two shots, we believe delivered after she ran around the front of the car, as she described. One of them at a slight from the right angle and traversing, and arguably that could have been delivered from the other side of the car as well. As she moved around, and he was in there trying to get further away from her. We know, according to what she told the detectives, that he tried to get away and tried to get out the door and shut it. And he crawled out of the car. Those are her words. He crawled out of the car. And then she ran around the front of the car and came around, and she said that she says he got up, she shot him again, he fell down, she shot him again. In here, she tells us a little different. I don't know that there's any comfort for her. She says, I went around the door and opened it. Now, why do you think she went around the door and opened it if that's what she did? If what she told the police wasn't true, but what she told you was true? Why did she go around there and open the door? She hadn't finished killing him. That's the only reason in the world for her to go in there and close with this man again, open the door and shoot him. That's her best story. That's the best story she has. The story she told the detective was he went down and she shot him again after he went down. And you know, that's confirmed, perhaps, certainly supported as a viable action, because the bullet, according to Dr. Body, went straight in. Straight in. And the others had an angle. It's the only one that went straight in, indicative of a shot delivered straight down. If you prefer to accept her version, she opened the door, and he's looking at her, and she shot him there. Either one is first degree murder. You don't have to debate on whether if she shot him lying down or if she shot him sitting up. The point is, she was going over there to kill him. And that's what she did. That's exactly what she did. It's what she meant to do. It's what she intended to do. And when asked why did you kill him? Right near the end of her testimony, she said, why?
Yeah, I think the Ted Bundy name's tied to publicly buzz pretty closely on YouTube. I've done a lot of Ted Bundy stuff, and then I did the first book club was the Ann Rule Ted Bundy book, so that makes sense. I bet there's a lot of keywords tied to publicly buzzed and Ted Bundy. Yeah, that's normal. That's something that's normal to do.
The police would never believe me. I'm a prostitute. That's the best story she has today. And so, inferences, therefore, I had no choice but to go ahead and snuff him out. Witness elimination. Witness elimination. Even if the whole story were true, and I submit to you it was not. But the last story she told her, even if that whole thing is true, she has absolutely no right to go over and snuff out his life because she's afraid someone might not believe her. She determined to kill him. For whatever reason, And she told us. Why would Ty Moore come in here, as Ms. Wuornos said, and lie? They were very close. They were good friends. They were lovers, close as peas in a pod, close as a knot. Heard all of those descriptions by Ms. Wuornos and not denied by Ty Moore. Ms. Wuornos says because she knew it was self-defense and she might be in trouble if she told it was self-defense. Now, how would that cause trouble? If anything, it might give some moral justification to the fact that Ty Moore didn't come forward and tell about this killing. That she believed her girlfriend was raped and brutalized, and therefore, because of horrible things done to her, she didn't tell anybody. Because the guy deserved to die anyway, and we're just not going to tell anybody. We killed a rapist. She killed a rapist, and we know about it. That would have been the most logical story if, in fact, it was true. But it wasn't true. It was not true, because it is not true, because she never told Ty Moore that. What she told Ty Moore, and told her several times just before the news came on, as she was drinking, Ms. Wuornos, and she knew that this car she'd been driving around in that day was suddenly going to be on television.
It is so strange, but what a shot of the entire jury there.
Because there was now a body. You know, simply an abandoned car doesn't make the news. Abandoned car linked to an abandoned rotting body makes the news 2 weeks later. 2 weeks later, she realized, uh-oh, Ty knows I have this car. Ty really didn't borrow this guy's car. I found a body in the woods where she started off. Found a body in the woods. And then Ty said, what are you talking about? And she used some profanity, got loose talk they use among themselves. And finally she said, well, I had to kill this guy. What? You're blanking me? Come on, you're kidding. No, I had to kill this guy. And that's it. Or I killed this guy. She didn't use the word I had to kill this guy. I killed this guy. And that was it. That was the whole story. This is her best friend. Roommates. Sweethearts. Companions. Doesn't tell her anything? That is incredulous. You don't need a expert, the way of a pathologist, who want to tell you what common sense tells you. In fact,
Solid
it
shot
was
of
for the story.
Eileen.
Now, the other reason Ms.
Come
Wuornos
on,
did this
Eileen.
is, well, it was a story. She wanted a story. She's going to make, gosh, I don't know, it sounded like $5 million or $500,000. Either one's a lot of money. She's going to make a lot of money by lying about this self-defense thing. Well, that's just not true, is it? Wouldn't it be a much more interesting story and a much more sellable story if this poor, pitiful prostitute simply doing her job, and some guy did some horrible things to her, and she killed him in self-defense? Now that's a good story. Got one that's even better. And then her girlfriend, who knew all about it, got on the stand and told the jury how it was self-defense and how when Aileen came in, she had bruises on her neck and hardly talked because the rope had almost choked her, and had been beaten brutally, and that she ministered to her private parts of her body because they were torn, and there was blood in her clothes and her underwear, and that this was a terrible thing. And then, despite the fact that this poor woman was raped and brutalized by this animal, the state of Florida tried to convict her. And a good, reasonable jury saved her. That's a good story. That would sell a lot of books and movies. And would be a gross injustice. The attack upon Deputy Horzepa, who is not responsible for what items are or not presented in evidence. The prosecution is responsible, along with the defense, ruled upon by the court, as to what you receive in evidence. Deputy Horace Zeppa has done nothing except sit here and testify under oath like any other witness and tell you what he did and what he had. She says she was cut off continuously, couldn't finish her statement. Her lawyer was sitting there. Would any lawyer, allow the police to cut off his client so she couldn't tell her story if she had a story to tell? In 3 hours and some odd minutes, you only have about 25 minutes of it, though. Is there one shred of evidence or testimony by her where she says that she was tied up even tied up? How about just stopping there? I thought the story was going to be a coat hanger tied her up. I thought they were going to say that she was tied up with a coat hanger. Remember all the big issue about was there a coat hanger, was it a straight coat hanger? And I didn't know, and we don't know where they're going. We just have to wait and hear it when it hits the stand. Same
Probably
as
on
you.
the screen.
So we spent, I guess, half hour on coat hanger. It didn't mean anything. In fact, we also didn't find any electrical wire, didn't find any rope. Abandoned in either place. Found the evidences of some drinking, perhaps some partying. She was told to tell it all. She was told you have an opportunity to tell everything. She did tell us something. She said what she deserved. But she never told anything about a rape. She mentioned the word rape a couple of times. Spread out over 7 stories of men. She never said that Mr. Mallory raped her. Certainly never said that he tied her to a steering wheel. In fact, if you recall, I asked her about this anal rape thing, and she said, no, that's a different one. That's a different man. Different one. Doesn't count. Can't talk about it. In fact, she's told you that virtually everyone in the courtroom has lied. Even Bobby Copas. Remember Mr. Copas? Looked like a trucker. I guess truckers are pretty big guys. I'm sure there's some skinny truckers out there, but most truckers look big, at least in the movies and on this witness stand in this case. Even Mr. Copas, she says, is a liar. And I don't like to use that word, but that's what she said. Because he wants publicity. Well, did Richard Mallory give her money in advance? And then was she afraid he wanted to take it back, as she said in her first statement? Or was he just a nice guy and she decided she could trust him and wasn't worried about the money until they got to argue about unzipping his pants, as she said in the second story? Had she had the gun 2 months or 2 days? Well, she corrected herself. She's the one that narrowed it down to 2 days. She's, oh, wait a minute, went back to that herself. It wasn't on prompting from anyone else. That's why we accepted that as the best version. Pretty good evidence. Because it was only a couple days after she said she got the gun the killings began. Something about having a gun that changes some people. And maybe it's a good thing we don't let convicted felons have guns, despite her view to the contrary. She was pretty astute on the stand, and certainly 2 hours on the stand or so would not be easy for anyone. But she was able to correct me on what pages in the transcript certain matters were. Oh no, that's on page 9. You better look over on page 53. I said, well, we haven't got there yet. We'll get there in a few minutes. Asked her about the trajectory of the bullet. Remember Dr. Body talked about the trajectory of the bullet? She said, oh, I thought the body was too decomposed for anybody to tell the trajectory of the bullet. She wasn't missing a lick. She knows what she's doing. And she has carried her pattern of manipulation into the courtroom to try to manipulate your verdict. She told you that she was threatened with the arrest and persecution and prosecution of Ty Moore, and that's the only reason she said all these things. I think that's a clear choice there. Either Deputy Morzeppa is flat sitting here and not telling you the truth, or she's not. There's no gray area there. Someone of the two is not telling you the truth. In fact, she told us in her testimony, she said, I'm the only one telling the truth. Everybody else is lying. I think she said, except me and my lawyers. But everyone else is lying. To convict an innocent person. She told Ty Moore just enough that Ty wouldn't flip out when she saw the car on the television she'd been riding around in 2 weeks earlier. And she didn't tell her anything else. Ty Moore should have come to the police. Ty Moore should have reported it. And maybe, just maybe, it would have stopped right here. Ty Moore is going to have to live with that. Ty Moore is not on trial. This is a murder trial for Aileen Wuornos. That's where it should have ended. This is because people don't want to get involved. And goodness knows, you've seen some witnesses here, you see why they don't want to get involved. But we've got to be involved. You've got to be involved. The system isn't going to work if we hide behind our privacy and our fears and our private lives. Ty Moore refusal to either believe or accept and believe and then to tell anyone could have saved 6 men's lives. And that doesn't hold her up for anything respectful or honorable at all. By the same token, if she'd been told this was a brutal anal rape, etc., it would have at least given her some moral justification for not saying anything. And she knows that. And she would have said that if it was true. Because it's not true, she didn't say it. It was bad enough that she didn't come forward. At least she didn't sit on that witness stand and lie to you to perpetuate and protect this woman who killed Mr. Malcolm. We heard a lot from her. This is a murder out of greed. This is a woman that can make, according to her own testimony, I don't care how you figure it, $30,000 to $50,000 a year and squander it just as quickly. This is a woman moving out of power and control into a new and unfathomable for you and I area of domination to the extent of snuffing out life. It became obscenely simple to have it all. Is there any answer to the whys and how did this happen? Not for this jury, not for this time, and not for us. She chose her life. She chose the time and the place. And she has left you no reasonable choice. No reasonable choice under the evidence of this case except to find her guilty of murder in the first degree and armed robbery. Thank you very much. Thank you, Ron.
Forgive me if I'm a little disjointed in my final remarks to you, members of
So this guy's back to lull us to death with his rebuttal.
the jury. I have a lot of things to respond to based on what you just heard. I would start out by agreeing with Mr. Tanner about one thing, and that is...
All right, I'm actually going to pause it there. We're going to come back to this. It's almost noon. I don't want to go get some food, honestly. So yeah, we still have, it's a little less than an hour, about 53 minutes left of the closings. And it looks like we're going to get the rebuttal by this extremely boring guy who is on Eileen's side. So this is the dude that opened. We didn't know who he was. But yeah, we will come back. That will be the starting point for next Sunday. And yeah, tonight I will be live on Wrestle Plunge, 6 Eastern. We're going to be we watch 2 episodes every Sunday night. I'm actually about to add a new show on Saturday nights. Yeah, and Pokemon knows this. She messaged me Thursday, and I should have made an announcement that I wasn't going live Thursday. But I haven't really done a live since before Christmas on a Thursday, and it was really just because of the holidays. But I think I am going to eliminate the Thursday night live streams here at Publicly Buzzed and add an extra day on Wrestle Plunge, which will be Saturday nights. It is going to be a late show, though. It's going to be a 10 p.m. Eastern show till midnight on Saturday nights, and I'm going to be watching an extreme... And it's also only on Twitch. It's actually not going to be on YouTube. The Twitch live streams will premiere later for Wrestle Plunge for this. But live on Twitch every Saturday night at 10 Eastern. And I would hope everyone follows me. Let me put the Twitch link in the chat too, because, you know, come in and join me. Have a good time. The wrestling that I'm going to be showing is Extreme Championship Wrestling from the 90s, from the Philadelphia area, and it's pretty wild. It's going to be a pretty fun, insane Saturday adventure that we're going to be going on. So, but yeah, please follow on Twitch. YouTube also, these shows will drop later in the week, but I can't live stream Extreme Championship Wrestling on YouTube, but I think that I can do a premiere and a video later, which is confusing, but I think that I can do it on Twitch. We're going to test the waters is what we're doing. I see another creator doing this in the wrestling community, so I'm going to give it a shot as well. But please follow on Twitch. I'm live every Sunday on YouTube and Twitch, which will not change. But yeah, definitely come through and hang out. But either way, I'll be back tonight. If you don't come through tonight, Sunday will be the next show. We'll be doing Sunday nights per the usual, 8 Eastern, some kind of body cam, some kind of crime-related content before we go into book club. Hell yeah, nice. We have to come in for a Friday show, Semi. We stream on there every Friday night. I'm all over the place. We doing the damn thing. We doing it. We doing it. Yeah, we doing it. All right, guys. Actually, I will set this up to send you to that stream tonight. If you end up there and hit a like, that'd be cool. I'd appreciate it. Boom, I just set that up. Oh, nope, fucked it up. But yeah, this was good. We are getting closer to finishing Aileen Wuornos, though. Holy shit. Another trial in the books, and we'll have to see what we do next. I think the next one I'm going to try to get a few together and do some kind of vote. Because I'd pick this one outright because this was almost the first trial I ever did. It was this one in Dahmer. And then this one has come close on a vote before. And this is one I wanted to always kind of watch because she's always intrigued me. So this has been very interesting and very cool. And yeah. All right. Come through tonight. I'll see you Tuesday otherwise. Have a great Sunday. Let's rock. Thanks, guys. Love you guys. Boom.
This hurts.